So Ashcroft versus Iqbal was a case that arose out of the treatment of detainees who were held after September 11th. And the allegations in the case were that detainees who were Muslim or Arab or South Asian were treated differently than other people held in federal detention, and that they were held in solitary confinement, that they were abused, that they were physically abused, that they were verbally abused, that they were not allowed to exercise. All sorts of mistreatment that would be unlawful if it was motivated by the detainee's race or religion or national origin. In the Supreme Court, the argument that we were making for Mr. Iqbal was that the complaint we had filed on his behalf sufficiently alleged a claim of intentional discrimination against the former Attorney General, John Ashcroft, and the current Director of the FBI, Robert Mueller. In the lower court, the government had moved to dismiss, and the lower court had rejected that request. And then it had been appealed to the Second Circuit Court of Appeals, and the Second Circuit Court of Appeals also said, we're not going to dismiss this case, the allegations are sufficient. And then the case went to the Supreme Court. Well, the court said that the complaint did not sufficiently allege that they were treated differently because of their race and religion by General Ashcroft and by Director Mueller. That was what the court said, and the court, in so doing, announced what a lot of people think of as a new pleading standard for federal cases. What it meant for Mr. Iqbal was that we had to go back to the lower court, and we had an opportunity to amend our complaint and to make it more specific, as the court suggested we needed to. What ended up for Mr. Iqbal is he settled the case with the United States. The United States offered to pay him a substantial sum of money so that he would settle his case. What it meant for other plaintiffs, I think, is that now, before you go into court, you have to draft your pleadings a little more carefully, sometimes a lot more carefully, if you want your case to survive a motion to dismiss so that you can get to discovery. What it's meant practically, there's a lot of debate about what it's meant practically. Some people have said that it's led to an increase in dismissal of civil rights claims in particular, and some people have suggested that actually it hasn't led to that significant of an increase in dismissal rates. And quite frankly, I think the jury is still out on that. I've conducted some research that suggests that it does have a significant impact, especially on civil rights claims, but I think there's more to be said about it. For most of the last 50 years, most states have followed the same procedures as the federal courts have. And in fact, the original federal pleading standard originated from state courts in a way. And so this is an opportunity now for state courts to decide whether or not they want to continue to follow the federal lead in pleading standards. And it's significant that so far 2 state Supreme Court cases which have considered the issue thoroughly have decided not to. They haven't thought that there was a substantial reason to do so, and they've found that any of the reasons that the Supreme Court might have had didn't really obtain in either their states or generally. Some have certainly suggested that the Iqbal decision was motivated in part by who the defendants were, and also the context in which the case arose, which was the treatment of post-September 11th detainees. Certainly some have suggested that. You know, my view of the court, and I respect the court greatly, and I ask my students to respect the court greatly. My view is always we have to take the court on its word. The court announced its decision. We might disagree with it. We might disagree with its reasoning. We might think that it should have waited or sought other kinds of input before making its decision, but it's made its decision, and it has given a reason. And so we have to take it on its own terms, and we and that's the best way, I think, to engage with the decision, and not, in my view, to spend time thinking about whether or not it would have been different if there were different defendants.